I think we're going to get started. And we have a lot of people still coming into the waiting room and joining us, but let's go ahead and get started. Welcome, everyone, to our CHIPS Accelerator. I'm Bridget Johnson. I'm CHIPS Director of Partnerships and Business Development, and we're absolutely thrilled to have Venable hosting our accelerator today. And Venable is going to be leading a discussion on the biggest updates in patent law in 2024. So before we begin, I just want to share two housekeeping tips with you. Number one, if you have a question for the Venable team, please enter that into the Q&A. There's a Q&A button at the bottom of your screen. It's a little square with a question mark in it. If you can't find the Q&A button, check out the button that says More. There are three dots there. If you click on More, you may find the Q&A button there. But please ask your questions in the Q&A, and Venable will be moderating those questions on an ongoing basis. The second housekeeping tip is that we are recording this accelerator, and it will be posted on both our website and our community platform so that you can share it with your colleagues who may not have been able to join us today. I'm going to turn this over to partner Sarah Brooks, who is going to be introducing her panelists from Venable, as well as the USPTO. Sarah?
Thank you, Bridget. Well, good morning, everybody. Thank you for joining us today for our Year in Review 2024 updates. My name is Sarah Brooks, and I'm a partner in Venable's Los Angeles office and the IP Litigation Technology Group. And with us today, we're really happy to have Molly Kachowski from the USPTO Rocky Mountain Regional Outreach Office. Thank you, Molly, for joining us today. With us today is also my partner, Elizabeth Mano, who is in the Venable's IP Litigation Technology Group in our Denver office. And then finally, last but not least, is my partner, Megan Woodworth, who is joining us from the DC office. She is also a partner in the IP Litigation Technology Group and the co-chair of Venable's IP Lit Technology Group. Can we advance the slide, Jessica? So today we're going to talk about 5 updates for 2024. There's an update in design patents, litigation funding, patent damages, PTAB ITC update, and an update on AI. Can you advance the slide, Jessica? Okay, so first on design patents, and we hadn't had an update really since the Apple-Samsung case, but this year, in May of 2024, the Federal Circuit decided a case, LKQ Corp versus GM Global Tech, in banc. And what they did was they overruled the prior test for obviousness that applied to design patents, and they held that the same test should apply for both utility patents and design patents. Now, courts had previously used a test for design patent obviousness called the Rosen-Durling test. And what that test did was it required litigants to identify a primary reference in which the design characteristics of the primary reference were basically the same as the claimed design. And if a litigant was unable to find a primary reference, well, then the design patent was not obvious. But if a primary reference was found, then the next step was to look at other references to see if they created a design with the same overall visual impression. And it required the primary reference to suggest certain ornamental features that would be applicable to the claimed design. So the Federal Circuit was concerned that this Rosen-Durling test was too rigid, and also that it conflicted with Supreme Court precedent. So what they did was they overruled the Rosen-Durling test, and they said that the Supreme Court test in KSR should apply equally to utility patents and design patents, and the Graham factors should apply to design patents just like they should utility patents. And so I think moving forward, the takeaway is is it could be easier to invalidate design patents due to obviousness. There's also some uncertainty, I think, with respect to how the second Graham factor in particular might apply to design patents. That second factor is whether the reference is relevant to the problem being solved. Because design patents are ornamental in nature, I think it's a little unclear what the problem being solved might be. So I'm going to turn this over to Molly for a question on how the USPTO has responded to this case and what's the USPTO's position on obviousness of design patent.
So of course, right, since we're in charge of actually issuing design patents, we had to comment um, on the case. But more importantly, right, we had to take a group of design patent examiners who were used to the Rosen Darling case, and then and applying those factors of obviousness and sort of change their mindset on how they're going to do obviousness now, especially since it is that flexible step. And so Director Vidal, of course, issued a guidance on May 22nd, 2024. As always, with whatever the U.S. Patent and Trademark Office is issuing to its examiners as far as guidance, it is also available to you. So it is on the internet on www.uspto.gov. You can read the guidance the same way actually that I'm reading it right now. Right, like, and basically what we did was we set up basically a four-factor inquiry. The biggest one, I think, is now that scope of the primary of the prior art that's happening in factual inquiry one, and that's where that primary reference again gets identified. It is analyzed in terms of its visual similarity to the claim design, but it doesn't need to be basically the same. It can be something that is in existence, but the more visually similar to the primary references to the claim design, the better position to design it examiner will be to set forth a prima facie case of obviousness. Typically, it'll be in the same field, but it need not be as long as the art's analogous. So I think that's a practice tip for practitioners in design patent world. And it didn't have to say what analogous is, but I think that will kind of fall out as people go through this. And we have been doing it, I think, since May of this year. I'm waiting until design patent day when I get to hear the update, but like everybody else. But then the examiner will move to design or factual inquiry two. And that's where the differences between the prior art designs and the claim at issue have to be determined. There is no similarity requirement as a threshold. It's just comparing the visual appearance of the claim design from the perspective of an ordinary designer in the field of the article of manufacture, which is actually, right, like it moves you into factual inquiry number three. Who is that person? I don't think that person is necessarily as complicated as the posita on the patent side, because you can get wildly variant opinions on who a posita is depending on the art on the utility patent side. But right, like that's one of the things. And then if there are present factors of secondary considerations that would act as indicia of non-obviousness or obviousness, that's something that the examiner should actually look at. So it's much more of a flexible approach. And I think the examiners are just kind of working their way through that and figuring out, kind of where some of those lines are drawn. But again, I think that also gives patent examiner or patent design practitioners the ability to really kind of argue and kind of, really come up with some creative ways of saying, no, this isn't. This is not the way that we need to be doing this. I think there's a lot of room now for argument. So I do expect that we'll be seeing a bunch of those responses from design patent practitioners.
It sounds like the scope of prior art that could apply then to design patents is broader than before.
Yeah, but I mean, the primary reference still needs to be analogous. So, right, are you really going to have as a primary reference if, the article of manufacture is a lamp? Are you really going to have, a car grill as analogous prior? No, right? Now, if it's a headlamp, maybe, but right, like I still think that there are some lines that design practitioners can draw about what is analogous and what isn't.
Okay. Um, well, that's really helpful, Molly. Thank you. The last thing I wanted to mention on design patents is the case that we have here at the bottom. This was a case that had been going on for years, and in fact, the parties had stipulated to the validity of the design patent. And after that stipulation was entered, then this case came out, the en banc LKQ case, and the defendant, Sirius, filed a motion with the court asking for the stipulation of validity to be reversed, and the court granted the defendant's motion. Now the defendant will be able to argue under the new standard that the design patent in this case is invalid. And again, I think, and I mentioned this before, that I think, at least in the litigation side of things, I think it could potentially make it a little bit easier to invalidate design patents, just because there may be, it's not such a rigid test, it's more flexible, and there may be other opportunities to invalidate design patent.
And Sarah, if we could, before we go on, we actually have an excellent question, I think, from the audience. To go back to Molly for just a second and kind of how this change may impact design patent prosecution specifically. Do you have any thoughts, or does the PTO guidance that's out there already, or anything that you've read or seen, impact what references will need to be presented to the patent office during prosecution, for example, in an information disclosure statement? Do we think that this change in law changes that standard in any way? And thank you to the audience for presenting those questions, and feel free to continue to do so through the Q&A.
I will actually say that that's a fantastic question. To my knowledge, I don't think that we've put out an official position on what or whether any changes to information disclosure statements need to happen as a result of LKQ. So I'll use the utility world, right? A lot of times there is, or at least there was from my own personal practice, like there was one reference that you knew needed to be cited on an IDS. Y'all know what they are. And right, like, and so you cited it on the IDS, but you still have the obligation of telling us what you know about. It isn't just that you cite just one primary reference in the utility side. And I don't think that that will be the case for the design patent world either. I think your obligations of disclosure are still your obligations of disclosure, whether they're design or utility, right? And that is, if you know about a reference that is pertinent to the examination, you've got to tell us about it. So I think, right, but we don't, on the utility side, we don't require you to say, hey, this is the greatest reference, right? This is what you need to look at. I don't think that we'll require that on the design patent side either. But if a practitioner knows, or the client knows of a particular reference that would be material to patentability, they're required to tell us about it. So I haven't heard anybody say that we're going to change the IDS rules for design patent practitioners in particular.
Any other questions, Megan?
Not going to come in so far. Thanks.
Okay, so let's move on. If we could advance the slide and then to the next one, actually, I'm going to skip ahead one. But the next topic we're going to talk about is litigation funding. There has been one interesting update in 2024, and that is a bill was introduced by two congressmen. It's the first bullet point here under proposed, and it was introduced on October 7th. I think it was contemplated before, but on October 7th, 2024, Congressman Daryl Issa of California and Congressman Scott Fitzgerald of Wisconsin introduced the Litigation Transparency Act of 2024. And so the proposal is to amend the United States Code to include a provision about disclosure of third-party beneficiaries, so litigation partners. And the motivation for it, I think, maybe it's twofold, but one of the motivations for the bill that I read was national security concerns. Apparently, some recent cases revealed that there were Chinese backed funders that fueled IP litigation against US companies. So that's one of the reasons. And then Congressman Issa said, we believe that if a third-party investor is financing a lawsuit in federal court, it should be disclosed rather than hidden from the world and left absent from the facts of the case. When we achieve a lasting measure of awareness by all parties, it will advance fair and equal treatment by the justice system and deter bad actors from exploiting our courts. So both congressmen that proposed the bill are Republican, and so given the changes in administration, it could be that this bill passes, and if so, it would apply to all litigation in all the federal courts. So that's an interesting update. Now, most people know about Judge Connolly's standing order in Delaware. That I think has been his standing order at least since 2022. And in his standing order, it's very specific to litigation funding. So his standing order asks you to identify the identity, address, and place of formation of the funder, whether third-party approval is necessary for settlement or other aspects of the litigation, a brief description of the nature of the financial interest, and then it also advises that a party can seek additional discovery, so the funding agreement, other things. So it goes beyond just identifying that there is a funder or that the name of the funder. Judge Connolly goes into detail. I guess if we could go one slide back. I just wanted to make note of the first case listed here. This is a case in which Judge Connolly in Delaware sanctioned parties for, I think this case was dismissed, and Judge Connolly had ordered the plaintiff to appear and answer certain questions. So rather than appear, they just dismissed the case, and he sanctioned the parties. I wanted to turn this over to Elizabeth to talk about, some of these decisions and what the takeaway is. I mean, is Judge Connolly out on his own here? Is he being affirmed?
Yeah, sure. And I just want to give a quick shout out to our colleague, Sophia Gunsberg, who helped us compile that list you just saw of all the different regulations that might come into play here. But yeah, I mean, I think the takeaway is it is different in each jurisdiction right now, unless that House bill we're talking about passes and it becomes uniform. You really need to pay attention to what district you're in, because it can vary, as you can see here. Texas courts have not been inclined to allow that kind of discovery. Delaware and California kind of are. So it really does matter where you are. The case, this Baker Top case you mentioned, Sarah, did go up on appeal, and the federal circuit affirmed the sanction. So I think the takeaway there is the federal circuit, at least so far, has not stepped in to stop any of these. So whatever jurisdiction you're in, that's probably going to be the rule, unless, we get to a new case where they give us some guidance on it. So I guess jurisdiction really matters, and it always does in patent cases for a variety of reasons, but now this is one of them that both plaintiffs and defendants will want to pay attention to, because it could really make a difference in the case.
And then if you could, Jessica, if you could advance the slide, one slide. I wanted to point out that I think there's a difference too between Judge Connolly's standing order, which is very, very specific to litigation funding, versus in the Northern District of California, there is a standing order that requires the disclosure of interested parties, and it could and probably does include litigation funding, but the standing order is not specific to litigation funding. And then on the right here, under enacted rules, we have we've cited other rules in which similarly, asking for parties that have a financial interest or a pecuniary interest. And this could be litigation funding, but it's really up to the parties to identify that and sort of like self-police it or identify it, versus like the Connolly, who's like, very specific as to what he wants to disclose and has sanctioned parties for not doing it.
I think we'll see there's a lot of litigation to still be had under these rules, especially with the cases we're seeing. So I would expect in 2025, we'll see a lot more litigation of some of these rules that may not even be like expressly say litigation funding, like you're saying, but that someone might want or ask a court to interpret that way. So I think we'll see a lot more of that next year.
Yeah. And also, as you mentioned, in terms of not just disclosure where there is a funder, but okay, you find out there is a funder, then you want the agreement, you think there's something, you want the litigation funding agreement or other documents related to the funding. It does vary by jurisdiction in terms of whether you're going to get that discovery or not. If we could reverse, sorry to keep going back and forth, but reverse the slide. As Elizabeth mentioned, in Texas, if you're asking for third-party litigation disclosures or agreements, they really haven't ordered that type of information to be produced, versus in California they have. And obviously, I think it goes without saying that in Delaware you would absolutely get that stuff. In Connolly's order, he specifically says that you can ask for it. So just be aware going forward, there's a proposed bill that might affect all federal courts. And if you find out there is a litigation funding through one of these disclosure requirements, then whether or not you can get discovery on it or other information will vary by jurisdiction for now. That's something to keep your eye on. Megan, I assume we don't have any other questions on this.
So actually, the question that we currently have pending is whether or not the slides will be available. And I'm not sure that any of us are prepared to answer that, but we're certainly happy to do so. So what we'll do is work with Bridget and the team at CHIPS to make them available to participants, whether it's on their website or ours after this. So I think that's another shout out to Sophia, though, on a job well done in helping us put them together.
Yeah, I think we can absolutely work with CHIPS to make these available. So thanks for asking that. And then on that note, I'm going to turn it over to you, Megan, to talk about damages and the update of patent damages.
Great, thanks. Thanks, Sarah. And thanks to CHIPS again for having us. It's great to see such a big audience. I think it's no doubt speaks to the energy that we all still feel after the most recent global summit, which was just awesome in terms of presentation and attendance. So glad to see that continuing to move forward with such enthusiasm. So the next topic that we're going to talk about is patent damages. Obviously, as many patent litigation practitioners are well aware, this is a topic that the Federal Circuit is about to take up in banc, which hasn't happened for quite some time. So where I actually want to start with this, though, is what hasn't changed, which is the statute. We all are probably familiar with Section 284, which provides very little guidance, but does say that upon finding for the claimant, the court shall award the claimant damages adequate to compensate for the infringement in no event less than a reasonable royalty for the use made of the invention by the infringer. That's basically all of the statutory guidance that we have. So from there, not surprisingly, we've had decades upon decades of litigation of exactly what that means in every case. it's a hotbed. It always has been for as long as I've been practicing, I know. And it seems like we are about to get a little bit more guidance. As I said, the Federal Circuit is taking up a case right now in banc. It's in the middle of briefing. And so, Elizabeth, I'm actually going to turn it over to you to give some background as to kind of how we got here and how we finally found a case that the court seems to think may be a good vehicle to provide additional guidance.
Yeah, absolutely. It really is interesting to see this rehearing that's happening and playing out right now. I think a brief was filed earlier this week on it. So we're kind of watching this unfold in real time. But I think it's been a while since the Federal Circuit has done that. So it will be really interesting to follow. But yeah, so the case that we're referring to that's there's a rehearing pending is the eco-factor case. But I think to understand the issues there, a good comparison is to look at this previous Wyland case that was from 2022. And what happened in that case, it's specific to damages, and this is all very high level, obviously. But basically, the expert there had opined that 2 infringed patents contributed to 75% of the value of the entire portfolio. And I'm sure if you've done patent litigation, you've seen this. There's portfolio-wide licenses. So the question is always, well, then how do you value 1 or 2 or a handful of the patents out of, dozens or hundreds or more of patents? And so in this case, the expert, opined that the 2 out of many patents had the bulk of the value. And the rationale behind that was basically, really only a handful of patents drive the royalty rate for a license. The rest is sort of just this like marginal upcharge was the language used. And then on appeal, the Federal Circuit rejected this. And key here was Judge Prost was on that panel, and the Federal Circuit reversed and found that that was not an appropriate apportionment of damages to the value of the patent. Then fast forward to this year in eco-factor, we have the same exact expert, which is interesting. And basically the same sort of scenario played out for his damages opinion. He opined that there was 1 patent found infringed, and he opined that drove basically the whole value of the licenses for a portfolio of many more patents, based on this, again, this theory that, well, the rest of the patents are kind of just thrown in for a little value, basically just like a bonus. And this 1 patent was really the driver of the value. But this time it was a different panel in part, and the Federal Circuit affirmed that. And on this time for the eco-factor case, Judge Prost, who was on the Wyland case, actually dissented, which is what makes it interesting because she was sitting on both panels. And if we could go to the next slide. Her dissent was pretty strongly worded, as you'll see some from these quotes here, basically pointing out that this seemed to be a contradiction to the case that was just 2 years prior, and really also raised this issue of, we've all been talking about the federal rules on experts and where, there's been some amendments and where is the line drawn? And she basically said the majority's decision, I have the quote here, to overlook the prejudicial impact of his unreliable testimony abdicates the court's responsibility as a gatekeeper and contradicts our precedent. So this was a very strongly worded dissent here. And I think I'll turn it back to you, Megan, if you want to talk about sort of the fallout from this and how we've got to where we are now with the rehearing.
Sure. Next slide. We have here just a few of the other cases that have come up just in the last 4 years. The specific issue that you focused on, Elizabeth, was really how do you value 1 single patent that's infringed or a couple of patents that are infringed when you've got an entire portfolio. And that's something that we're seeing over and over and over again play out. It was an interesting part of this case. It's also been a part of, the 3 cases that we have here and many others, including a GlaxoSmithKline case that was even on the pharmaceutical side that the Vectura case that wasn't mentioned here. But so we're seeing that kind of scenario play out repeatedly, and the court hasn't been entirely consistent with the way that it's treated it. And neither have district courts. It's kind of similar, I think, to what Sarah and Elizabeth were alluding to in terms of the discrepancies among district courts in the way that they're treating litigation funding. We're seeing a similar discrepancy in the way that they're treating experts. Many of us know that several district courts and district court judges in particular, take a very hands-off view when it comes to excluding experts and don't want to do so. They don't want to interfere with the role of the jury. And so they often see this as issues, challenges that are raised at Daubert as challenges that should go to the weight of the evidence, as opposed to its admissibility. And so we're kind of seeing the Federal Circuit apply a similarly hands-off approach and giving the district courts deference in terms of whichever way they come out, almost rubber stamping that. And so if we could turn to the next slide, what we see is, I think that it is the confluence of the number of cases where these multiple portfolios are coming up and the court struggling, depending on which district it came from or which judges are sitting on the particular Federal Circuit panel that's reviewing it, that we're coming to some different decisions. And so they have decided to take it in banc, which I hate to read tea leaves, especially when it comes to the Federal Circuit or the Supreme Court. But obviously, they take a case in banc when they want to make a more specific pronouncement. More often than not, I think where the expectation is they take a case in order to do something different. So I think that we've got to expect that we're going to see a potential change in this case. But one thing that I think is interesting about this, the order that was granting the en banc petition is how broad it gets. The first statement that you see here is that they've asked the parties to address the district court's adherence to the Federal Rule of Evidence 702 and the Daubert standard. And then it gets more specific into Ecofactor's damages expert assigning a per unit royalty rate to the 3 licenses that were in evidence in this case. But it's really that broader starting point for the order that I think is so interesting. And it's something that Judge Prost picked up in her dissent, is the appropriate line here is set by Federal Rule of Evidence 702. And there was an amendment in 2023. It was meant to be a clarifying amendment, but it came with some language in the notes that accompanied it and in the buildup in the committee that led to the change in amendment that suggested that it was meant to be a pretty significant change, albeit a clarifying one. I've got here one of the memos, and this was from June 2022, and it was a memo by the person who was acting as the chair of the advisory committee for the rules of evidence, and that's United States District Judge Patrick Schlitz of Minnesota. And what he said was, many courts have declared that reliability requirements set forth in 702, specifically subsections B and D, that the expert relied on sufficient facts or data and has reliably applied a reliable methodology, that these are questions of weight and not admissibility. And more broadly, that expert testimony is presumed to be admissible. These statements misstate Rule 702 because its admissibility requirements must be established to a court by a preponderance of the evidence. And so ultimately, that's exactly the clarifying amendment that we saw brought in. Now, it's very clear from the rule itself that the proponent of the evidence, the person that's trying to put a particular piece of evidence or in through an expert or the expert's testimony itself, has to show that it is reliable by a preponderance of the evidence, both in terms of its inputs, what it's relying on, as well as its application to the facts of the case. And I think that this was a big impetus, not just the potential disagreements among different panels or even disagreements among district court judges. I really do think that this change in the rule and the strong language that came with it was important. Because we saw that also, and I want to highlight a couple of these, there were several amicus briefs that were filed just at the petition stage in support of Google, which I think is the other party to the Ecofactor case. I'm not sure if we had mentioned that, but they were the defendant that was facing what ultimately was a $20 million verdict. And so they're the ones that have been asking for rehearing in banc. And there were a couple of amicus briefs, 2 in particular that I want to mention, that brought out exactly this issue. What does Rule 702 require? Who does it put the onus on? How stringent should a district court be looking at the evidence before it actually allows it to go to the district court judge. And so shout outs to, I don't know if anyone in our audience today worked on either of these briefs, but I thought they were both excellent. One was put together, it was a collaboration between Intel and Dell, who are obviously, you know, frequent defendants, have very high-tech products that encompass numerous patents, and so have to deal with damages and patent stacking and some of these issues that the royalty and patent damages so frequently touch upon. But they were one that brought up 702 and whether the court's Ecofactor Google case lived up to that standard. They said that judicial gatekeeping is essential because just as jurors may be unable, due to a lack of specified knowledge, to evaluate meaningfully the reliability of both the scientific and other methods, which would encompass damages that are underlying expert opinions, jurors may also lack the specialized knowledge to determine whether the conclusions of an expert go beyond what the expert's basis and methodology may reliably support. So I thought that was really well said, and it really spoke to something in the majority opinion in Ecofactor, which actually said, we're cautious, we don't want to go too far. The majority opinion actually came out and said expressly that if the standard for admissibility is raised too high, then the trial judge is no longer acting as just the gatekeeper, but assumes the role of the jury. And I think that briefs like this, like the one filed by Intel and Dell, really challenged the Federal Circuit that they had set, at least in this case, had set that bar too low. And then another brief that was filed, amicus, by the Lawyers for Civil Justice. So obviously a much broader group than anything patent specific. And this took an even broader approach, and it challenged the Federal Circuit for not just its specific majority in this case, but it actually looked back to other cases, like the active video case from 2012, and similar statements that were in an Apple versus Motorola case from 2014, where the Federal Circuit likewise took an approach that was suggesting that these issues should go not to reliability and exclusion, but to the weight of the evidence. And this amicus brief came right out and said, decisions in this circuit fall among the body of rulings that do not adhere to the requirements of Rule 702. And then they actually quoted the example from Apple Motorola, where the Federal Circuit declared that the soundness of the factual underpinnings of the expert's analysis is a factual matter to be determined by the trier of fact. So I applaud the amici that have come out that supported at the petition stage. As Elizabeth said, we just saw the first brief come in from Google this week. So I'm very hopeful that in the coming week, we're going to see even more amicus briefs that really do help the Federal Circuit navigate Rule 702 as it's now been clarified and intended to be implemented.
Megan, we had one question come in related to standard essential patents and whether damage assessment and standard essential patents is different from non-standard essential patents. I think the question is going to address the issue of whether the analysis we're talking about here, Ecofactor versus Google, would apply to standard essential patents.
That's another good question. And I think that the issue that we're talking about here today, yes, it should. Obviously, the Federal Circuit has said that there's a slightly different analysis that should be applied to the extent, for example, that the court is utilizing the Georgia-Pacific factors for determining what the reasonable royalty is or should be, that there are certain of those factors that are more or less relevant in the case of a standard essential patent. But as it relates to the apportionment that should be done from any license, and how that needs to be done and how it needs to be done reliably, I think that should be the same for standard essential versus not in the analysis. And my hunch is that the Federal Circuit won't say anything specific about standard essential patents in this in this, whatever its upcoming in-bank decision is, but that it will have applicability to those cases as well. And Elizabeth, I don't know if you have any, or Sarah, if you guys have any other thoughts on that? Because
No.
obviously, yeah.
I think that's right. And I think this issue is going to, whatever happens in this eco factor case is going to be a really big deal for patent cases going forward, because we just, like Megan said, it comes up in almost every case. It's across the board, all different types of technology, like everyone's facing this issue of apportionment. And so I think this is going to be a really big one to watch. And I guess we'll have to do the update next year, what happens.
I have one more question that came in, if we have time to address it quickly. A question about why the Federal Circuit rejected the expert's opinion in Wyland, but affirmed the same experts, virtually the same expert opinion in the subsequent case.
I mean, I think that,
a different panel, but that's the question.
I mean, I think that's the implication. There are two different panels, because the one judge who was on both panels disagreed and dissented in the second one. So I think it was just two different ways of interpreting it. And that's why we're going to get this in banc court to tell us what the final answer is, because there's been sort of, what Judge Prost called, inconsistent and muddled precedent, which I think all practitioners want a clear answer going forward on what we should be doing. So I don't know why, but I think it is just different interpretations is my impression. I don't know if you agree.
There was just one additional piece of evidence that had come from, and I think some of this was even redacted in the public version of the Federal Circuit opinion, but there was additional evidence that came from internal Google files that the majority in that case, in the ecofactor case, tried to use, and the expert had used as kind of a check on his original analysis. So I think that did give them some comfort that what he had done was not precisely what had been done in that prior Wyland case, but was actually more closely aligned to the facts of the case because of the additional Google document. But it's worth, again, reading Judge Prost's dissent in the ecofactor case as to whether or not that was anything more than smoke and mirrors. All right, and with that, we're going to turn it over to, and if we could advance the slide, we're going to move on to IP related. This has to do with a Supreme Court case that I know that I had been waiting on since at least Judge Gorsuch was appointed to the Supreme Court in 2017. If not that day, then immediately upon the Supreme Court getting a 6-3 majority of conservative justices, I think that most in the legal world kind of saw the writing on the wall and saw this one coming. And that is death to Chevron deference. So for anyone who hasn't been following regulatory agency deference that closely, just to give a very quick background, Chevron versus Natural Resources, which was a case that came out in 1984, it applied to basically the review of regulatory agencies' interpretation of statutes. So obviously, I just read the damages statute. We know how little Congress can often agree on. So often statutes are written very short, very curt. And there's a lot of wiggle room that is left to agencies to interpret in carrying out those statutes. And so when Chevron came up in 1984, it was at that time a landmark ruling that decided that where there is ambiguity in statutes, that it was best for the judicial branch to rely upon the regulatory branch and to rely upon the administration and the regulators that were carrying out the statutes day to day to interpret those. And so where there was ambiguity and Congress had not spoken directly to the precise issue at question, the courts were going to allow the regulatory agency's interpretation to stand so long as it was a permissible construction of the statute. So if the interpretation was clear, if there was a plain meaning, the court would go ahead and apply that. or if Congress had spoken to the issue, they would apply congressional intent. But where there was ambiguity, Chevron said, let's leave it to those who do this every day. And so long as they've got a permissible interpretation, we're going to not second guess it, and we're going to give them deference. For 4 decades now, that's been known as Chevron deference. All that came to a halt in earlier this year with the decision in Loper Bright, in which the Supreme Court directly overruled Chevron, directly overruled that type of deference, and said that it defied the command of the Administrative Protection Procedures Act, the APA. And so what they said is that the court that they are required to exercise independent judgment to decide whether an agency was acting within their statutory authority, rather than deferring to the agency's interpretation of ambiguous statutes. Now, most likely this leaves us in the pre-Chevron world, which applied something that I think I learned about in law school called Skidmore deference, which is certainly something less deferential than Chevron, but does still look at the regulatory agencies. It doesn't look anew at the statutory interpretation, but will actually look to the regulation, look to how the agency is interpreting a statute, but how much deference it actually gives to that depends on a number of factors, including the thoroughness of the consideration that they gave it, the validity of the reasoning, how consistent it is with past precedent, etc. So basically, there's a lot less deference and a lot less certainty as to what a court is going to do when it reviews an agency's interpretation of statutes. Now, that alone could sound like the sky is falling, not just in the IP world, but basically anywhere that there is regulatory involvement, because it really sounds like it's a free-for-all now to reconsider the way that all statutes are going to be interpreted. But we know that that's not exactly the case. Justice Roberts was very clear in the majority that he's a strong believer in stare decisis. He said that this should not call into question every past case where the courts have relied upon Chevron deference in interpreting or affirming a regulatory action. He said that if you litigants are going to try to challenge a case and a decision that has already come before us or before a court in interpreting a statute, that you have to have special justification in order to get a redo of anything that's already been decided. So for new cases, new decisions, new interpretations, we know we're in this wishy-washy Skidmore world. For older ones, we now know that you've got to have a special justification in order to have that relooked at. Although I loved Justice Kagan's dissent, which basically said that it's very unclear what special justification is going to mean, other than any justification that a particular court may want to redecide a particular issue. So certainly we're in a land of uncertainty as it relates to regulatory interpretations. In patent law, this is obviously most likely to have an impact in the Patent Office, the Patent Trial and Appeal Board, and then in the International Trade Commission. So with that as a background, I'll turn it over to Molly to give us your thoughts and tea leaves as far as it goes in the PTO world.
I will say, like, I agree with you that anybody who knew Justice Gorsuch knew that the Chevron death was coming. He was so vocal about that. But yeah, for the U.S. Patent and Trademark Office, we honestly don't expect a whole lot of impact. We do not consistently rely on Chevron deference in asserting the USPTO's positions on our interpretations of statutes. We really do have a lot of express rulemaking, especially for our core functions. So we don't think there's going to be a huge, wide, sweeping effect on, the way that the agency does its business. We consistently, because right in overturning Chevron, it's the role of the courts to identify the best possible interpretation of the law. So a court shouldn't defer to an agency's interpretation of that statute. But when Congress makes an express delegation of rulemaking authority to an agency, the court's role changes to say that, like, did the agency act reasonably and within the bounds of its authority? And we, so like I said, we rarely invoke Chevron deference. The Federal Circuit has granted it to us even less frequently than we've tried to invoke it. So we really don't litigate with the expectation of receiving deference, and we don't approach rulemaking with the expectation that we would receive deference, right? So we approach our rulemaking with we want to, in our litigation posture, we will assert that our interpretation is the best reading of the statute under standard statutory construction canons, supported by strong policy rationales. And then those rationales are underscored with our technical legal arguments that are grounded in statutory text, controlling precedent, any of the other, kinds of things that we can rely on, legislative history, whatever that might look like, that will lead to the right outcome for the IP system. So I think, right, I'm not saying we're not too concerned. I mean, we followed the case pretty closely, but it will come down to almost a case by case basis for any action that someone might want to take in terms of challenging the USPTO's authority to enact rulemaking and to push rules through the system. So we'll see what happens with that. But it will be on a case by case basis for sure.
Great, thank you. And I think the same can be said in some ways for the ITC. I think there are more specific examples. The Suprema, of course, case that we've got here is one listed, where over and over again, what the ITC and the Commission is doing is interpreting Section 1337 or 337 to determine, what are articles that infringe, which was the issue in Suprema. Does it have to infringe at the time it's imported, or is it sufficient if it's imported and it's going to be infringing thereafter? I think the other one that is pretty clear that is going to get a Chevron or Loper-Bright type challenge is to how the Commission interprets the domestic industry requirements. What constitutes a domestic industry, as well as what it means to destroy, substantially injure one, prevent the establishment of one. I expect that in all of the cases in which those are being litigated, how much deference should be applied to past Commission precedent is going to be at issue there as well. And so I think those are probably the ones that most people are forecasting, but I think it's still TBD in order to see kind of where it's going to come up and how it's going to play out. But with that, I'm going to turn it to the next slide. I want to make sure that this is 2024, so we cannot do a greatest hits or what's going on in the current IP space today without giving some lip service or some discussion to artificial intelligence. So with that, I'll turn it back over to Elizabeth.
Yeah, you're absolutely right, Megan. Of course, we had to cover this. So I know we're running a little short on time, so if we could just skip to the next slide. AI is, it's here, it's been here as far as tools and using in litigation. I mean, for years we've had OCR and text recognition and things that, we would maybe now say is AI, like the early beginnings of it. So I think it's here to stay. And I have had the chance to play around with some of the tools, which has been fun. I actually used AI to help me research some of these points here. So it can be a useful tool. But yeah, I think what I want to just cover here with our limited time before I turn it over to Molly to talk about the USPTO side of things is just that we are seeing a lot of local rules and standing orders come out about AI. And so you can see some of these here. I mean, it is actually interesting. Some of them require affirmative disclosure if you're using any sort of generative AI, especially. They require, certifications. The lawyer who's signing it is certifying certain things. So you definitely, again, just like we were talking about earlier with litigation funding, you need to know your jurisdiction. Interestingly, here, the Fifth Circuit actually decided not to adopt a special rule for AI. So that's, the other side of it. Not every court is doing it. Although they noted, you're not going to get away with something sanctionable just because you used AI. As they said, I used AI will not be an excuse. So there is definitely different opinions among different courts. And if we can go to the next slide, there's also a lot of standing orders for different judges, again, requiring, affirmative disclosure, certification. Sometimes you have to say what program, what parts of your brief might have been drafted by it. I think my takeaway from this is a lot of them are concerned about, I think we all heard about the case or multiple cases now where AI came up with fake citations that sounded like real citations, but were not. And I think these are judges trying to get ahead of that and basically making sure that our lawyers in their court know that they're going to be held responsible for this. So you don't just like get out of jail free because you used AI. So again, for practitioners, I would say just making sure like check on your judge's standing order that you're before, check on the local rules for AI, and then just be aware of them, because if you're using AI, you may have to disclose it. And so you want to make sure or if that may change your decision on whether you want to use it. But I thought the amount of courts, and this is not a complete list here in this presentation, but the amount of courts that have this or standing orders that have this requirements of affirmative disclosures is quite a lot. So I think that is the trend currently, at least until maybe local rules have more consistent guidance. So I'll turn it over to Molly. What is the USPTO doing on AI in 2 minutes?
So 2 minutes. Obviously, we're using. We want to implement AI as an efficiency tool, but we're keeping human beings at the center of any decision that we make about implementing AI. What we want to do is use artificial intelligence tools to help our examiners do a better job, a more efficient job, along all of those lines. The primary practice pointer, though, for all of you is again, this is in keeping with keeping the human at the center. We like to remind people that when you sign something in front of the U.S. Patent and Trademark Office, whether it is a patent application or whether it is a patent trial and appeal board brief or whether it is a trademark trial and appeal board brief, that is your signature on the line. So whether the brief was prepared by AI, whether it was prepared by an intern, a young associate, whoever, when you sign it, you are vouching for the accuracy of the information in there, and you are advocating for those positions. And if it turns out that you do cite something to us that is made up by artificial intelligence, it will be you that we will be talking to, not the artificial intelligence tool, and it won't be a defense. You have to decide, you're signing the paper. So we put that guidance out, I think, over the summer about that. And then, like I said, everywhere else that we're using AI, it really is keeping the human being at the center of implementing those tools, which of course is also what President Biden and his administration has put forward in the executive order about how we will look at regulating artificial intelligence tools in the future. So the only other practice pointer that I would call out is I really do think that the next 2 months probably are going to see a slew of things come out. The executive order was very clear about timelines, but of course, the runway has been closed. We know that there's a closure of the runway as of election day. So I think to the extent that agencies are going to be implementing more regulations on AI, that's definitely going to be coming down the pike pretty fast and furious over the next 2 months. And I will say, right, like that's also the point where we are seeing, even in some of our own comments to some of the things that we've proposed, we are seeing a little bit more of that Chevron, the Loper Bright kind of questioning whether the USPTO has the authority to issue that either guidance or proposed rulemaking. So if there is one effect that Loper Bright is having, it's going to be that we're going to have to sift through a few more of those comments. But as all of you know, we read every single comment that you submit to us. Multiple people read them. So again, I always tell people, please, if there is an issue that you care about, I know you have to read the Federal Register, and I know what a problem that is. But if there's an issue you care about, read the Federal Register. Please give us your thoughts. Your thoughts are considered very, very carefully by multiple people at the agency. And we really can't do substantive rulemaking without your thoughts on those subjects. So please definitely comment.
Thank you. It's so great to have you here, Molly, and share your insights on that. We're very lucky to get a view into the USPTO, so thank you. So I don't think we have any more questions, and I think we're past our time, but if anyone has final questions, put them in. But if not, Sarah, I don't know if you have any closing remarks you want to make. We're grateful.
I was checking the questions. I don't see anything else in there, so I think we are out of time. But thank you, everyone, for joining us today.
Yeah, thank you, Chips, and thank you, everyone, for having us.
Thank you, Venable.
Thank you, Venable. Panelists, if you don't mind staying on for just 1 second.
Sure.
Thank you.